Hello and welcome to another edition of Gough Square Live. As you can probably tell from the surroundings and my attire, we're doing things a little bit differently at the moment. Needs must. Usually when we present a Gough Square Live, I have a team behind the camera pulling all the technical wizardry, and I have someone much more photogenic sitting next to me to take away the attention from me, who will answer all the questions that you send in via the YouTube channel. However, like most of the rest of the population, I'm currently confined to my house, which means therefore I'm not in chambers, and I don't have anyone else to do it with me. But Gough Square Live, we're not going to let the situation get ahead of us, and if nothing else, we think we've probably got a captive audience with all of you at home, so we're going to try and take advantage of that and put on a few short talks trying to discuss matters which may be of interest. I'm going to put on a small number of talks dealing with contractual issues in the light of the coronavirus. This talk is going to be about how you can give your customers time to pay if they're experiencing financial difficulties without falling foul of regulation under the Consumer Credit Act 1974. Because we're lawyers, we don't want to fall foul of the word live in Gough Square Live, so the way that this is going to work is this video will be posted on our YouTube channel. It is not live, I am not currently broadcasting now. However, there will hopefully, assuming I can master the technical wizardry, be an email address and a time displaying at the bottom of the screen about now, which will give you an email address by which you can contact me at a time by which I will make sure I am sat at my computer and not homeschooling my children, and you can fire questions off at me. And assuming I don't get too many all at the same time, I will give you a response. If you are not free at that time, and I'm well aware that we're all trying to juggle our time at the moment, then by all means just email the email address as and when. I promise I will get to it as and when. Okay, going to start then with, well, how can you give your customers time to pay while avoiding the Consumer Credit Act 1974? There are two main ways which we can do this, and I'm going to look at both of them. Firstly, if you make payment arrangements with your customer, do so in a way that does not give rise to a contract. And secondly, try and rely on a Consumer Credit Act exemption. In very basic terms, Section 8 of the Consumer Credit Act 1974 regulates agreements between an individual and another person, the creditor, by which the creditor provides the individual with credit of any amount as long as the agreement is not exempt. What the meaning of credit is given in Section 9 of the Consumer Credit Act, and it means a cash loan or any other form of financial accommodation. There is little doubt that allowing somebody time to pay something which they would otherwise have to pay at an earlier point in time can be financial accommodation. So if you give your customers time to pay, you're potentially giving them credit. As long as your customer is an individual, and the definition of an individual includes a partnership of 2 or 3 partners or an unincorporated association, and you're providing credit of any amount and there is no exemption, then you are therefore potentially within the scope of the Consumer Credit Act. What this means, however, is if you're providing credit to a body corporate or a large partnership, you don't need to worry about the Consumer Credit Act, and you can probably stop watching now. Note, however, that the word consumer in Consumer Credit Act is a little bit misleading, because business loans can fall within its ambit, albeit, as we'll see a little bit later on, there are some exemptions that apply to business loans. But in general terms, if you've got a customer who's a sole trader, say, an individual, and you are providing them with time to pay, it doesn't matter that this may be arising in their course of a business. They may nevertheless themselves find them. You may nevertheless find yourself providing regulated credit. So then, how can you avoid this? 2 different ways. 1, do not have your arrangements form a contract, or 2, rely on a consumer credit exemption. In terms of stopping your agreement being a contract, because the Consumer Credit Act regulates agreements, it's generally accepted that the word agreements means contractual agreements. And if you can avoid a contract arising, then it's usually thought you do not need to worry about the Consumer Credit Act. One way you can do this is by trying and structure your arrangements in such a way that there is no consideration. It's long been the case, going back to, I think, my contract law teaching at university, a case of Folks and Beer, which I think is about 120 years old now, that you do not provide consideration if you promise to perform something which you're already contractually obliged to perform. So if you have a customer and your customer is already obliged to pay you and you give them time to pay, the argument goes, well then they're not promising to do anything that they were not already promising to do, and therefore there's no consideration, and without consideration there can be no contract. This is a good argument, and simply if you just stop there, you may well be fine that as long as you do structure your arrangements in that way, you're okay. But there are some problems with it. Firstly, there has to be no consideration. And for there to be no consideration, what this means is there can be no benefit at all that your customer is giving you, say, as a result of the arrangement. So you can't charge them interest if interest wasn't otherwise payable. You couldn't take security for the payment obligations. You couldn't change the terms and conditions so that they were more beneficial to you. Because if you change what you're entitled to, then there is consideration that comes from the customer. And in that situation, the Folks and Beer argument simply doesn't work. Okay, their customer is giving you something they were already obliged to do, i.e. the payments, but they're also giving you something else, the interest, the security, or the change in terms, whatever it may be. So first of all, if you want to rely on this, do not take anything else. Limit yourself to what you were already promised under the contract, i.e. the payments. But the other problem with the argument of simply saying there's no consideration is the courts will sometimes try and find a way around this. And they have been known to find what's known as a practical benefit to the other contracting party. In the case of Williams and Roffey Brothers, there was a carpenter who was a subcontractor and was paid £20,000 by the main contractor to carry out various carpentry work. But it wasn't enough. The works weren't going to get done. The main contractor therefore promised to pay the carpenter more. The carpenter did the works. The main contractor didn't want to pay. But it was found that there was consideration here, because although that the subcontractor was doing nothing more than it had already promised to do, therefore was providing, wasn't providing consideration because simply promising that to do which it already had to do, it was said there was nevertheless a practical benefit to the main contractor, because without the extra payment, the subcontractor wouldn't have done the work, and the main contractor then might have found themselves subject to penalties for themselves being in breach of contract in not carrying out the works. And it's not difficult to see how you might be able to construe a similar argument in terms of a customer or a person who is in financial difficulties, who is simply not otherwise going to pay you. If you're not going to get your money, maybe they're going to go bankrupt. And the only practical way you're going to get their money is by giving them time to pay, to allow that customer time to get over their payment problems or the situation that we're all facing at the moment because of the pandemic. Then you can see there might be an argument that there is a practical benefit to you there by virtue of getting in money which you otherwise would not have got. And the other problem with relying on the Folks and Beer is that the Supreme Court have recently examined the relationship between Folks and Beer and Williams and Roffey Brothers in the case of MWB Business Exchange Centres Limited and Rock Advertising. And the Supreme Court, although it didn't have to decide the issue, recognised that there was a tension between Folks and Beer and Williams and Roffey Brothers, and said that Williams and Roffey Brothers may well be inconsistent with Folks and Beer. Folks and Beer's House of Lords, Williams and Roffey Brothers' Court of Appeal, so ordinarily Folks and Beer would take priority, but what the Supreme Court said is it may be necessary to revisit Folks and Beer, but didn't go as far as doing so. So there's a little bit uncertainty at the moment of simply saying, well, we can say that there is no consideration because the other party to the contract is doing no more than they were already promising to do. The Supreme Court hasn't overruled it, but it's put a little bit of a question mark in relation to it. So what then can you do? The answer is possibly don't just rely on no consideration. One other way that you can make your arrangements not contractual arrangements is by making sure that there is no intention to create legal relations. And one way that you can do that is by very careful drafting of your communications with your customer. And you can make it clear that you are not forgoing your existing rights, you're not binding yourself to anything, you're just giving some kind of indulgence. Make it clear that you can insist on your strict legal rights at any time, and make it clear that you are not entering into a contract. Couple that with the argument that there is no consideration, so make sure that you don't take anything extra, don't take interest, don't take security that you're not already entitled to. The two things coupled together probably give you a very good argument that there is no contract and therefore the Consumer Credit Act isn't applicable. It's not particularly pleasing for a customer to receive a letter saying, well, you're not binding yourself to it and you can revert back to your strict legal rights at any time, but that's probably a better place to be than find yourselves inside the scope of the Consumer Credit Act by mistake. If you enter into regulated credit in the course of a business and you do so without FCA authorisation, you commit a criminal offence. Also, not complying with the applicable financial services legislation can also give you problems in enforcing the contract. So you may simply find you can't get the money back that you have very kindly allowed the debtor time to pay. So in summary, if you want to go down the no contract route, do two things. First of all, do not take any additional benefit from the customer, and secondly, make it clear in your communications with the customer that you are not entering into a contract, that you are not binding yourself, and you can revert back to your strict legal rights at any time. Okay, so that's the first way that you can potentially avoid Consumer Credit Act regulation. The second way is to use the Consumer Credit Act itself and to rely on a Consumer Credit Act exemption. And there are four that we're going to look at, although unfortunately they all have their potential problems. We're going to look at the exemption in Article 60F, and you'll find all these exemptions in the Financial Services and Markets Act 2000, Regulated Activities Order 2001. And Article 60F provides for an exemption for borrower-lender-supplier agreements with 12 payments or less inside 12 months interest-free. There is an exemption in Article 60C for business loans over £25,000. There's an exemption in Article 60H for high net worth debtors, and an exemption in Article 60G for certain low interest rate loans under borrower-lender agreements. I'm going to start with Article 60F. This applies, as I've already mentioned, to certain types of agreements, borrower-lender-supplier agreements. There can't be more than 12 payments. These have to be made inside 12 months from the date of the agreement, and it has to be interest-free. The problem with this exemption is that to be a borrower-lender-supplier agreement, to fall within the statutory definition, any arrangement that you make with your customer must take place before the customer's time to pay has arisen. If the customer has already become obliged to pay you and then you make payment arrangements with that customer, then that is not a borrower-lender-supplier agreement. What you are doing is refinancing an existing indebtedness, and as a consequence that is a borrower-lender agreement within the meaning of the Consumer Credit Act. So for this to work, you need to make sure that the arrangements you make arise before the customer has missed a payment to you. If you can make that work, then you need to make sure there's no more than 12 payments. You need to make sure that those 12 payments fall within 12 months from the date of the agreement, i.e. the arrangements that you make with their customer. Make sure it is inside 12 months. For example, it's quite common under credit agreements to structure your arrangements as, well, we'll provide you credits on, say, the first of the month, your first payment is the first of the next month, and the first of the next month, etc., etc. If you carry that on for 12 months, you'll find your agreement doesn't last 12 months, it lasts 12 months and a day. So an agreement that starts on, say, the 1st of January, with 12 consecutive payments starting on the 1st of every month thereafter, is 12 months and a day, and that is enough to stop the exemption from applying. And you also need to make sure that you do not charge interest or other charges. But that has some potential use, providing you can reach arrangements before the customer has been, before the customer's time to pay has arisen. The second exemption is in Article 60C. This is a little bit more straightforward. This is an exemption for business loans over £25,000. That is a loan which is wholly or predominantly for the purpose of a business carried on by the debtor. You can, if you want, put a declaration in the agreement to this effect, which gives rise to a presumption that the loan is for business purposes, as long as the creditor doesn't know or suspect that that's untrue. There's a prescribed form of wording you need to use if you want to rely on this presumption, but it is not mandatory. You do not need the business purpose declaration in to be able to rely on the exemption. You simply need there to be credit over £25,000 and the loan for its business purposes. The third one we're going to look at is the high net worth debtor exemption. If £25,000 was high for the business purpose exemption, to be able to rely on this, the amount of credit has to be 60,260, or at least more than 60,260. I suspect this isn't going to help in the majority of situations, but if you do find yourself wanting to provide time to pay for such a large sum, then you can do so as long as the debtor is a high net worth debtor. They have to have income of £150,000 or more in the previous financial year, or they have to have net assets not including their home or a small number of other rights such as pension rights of over £500,000. If you want to rely on this, you need to get a declaration in the prescribed form in the agreement which the customer should sign, but you also need to get a statement from an accountant, in essence certifying that the borrower satisfies those requirements. And the final exemption I'm going to talk about, mainly just to say why it isn't applicable rather than it being potentially applicable, is the low interest rate exemption in Article 60G. This is an exemption for borrower-lender agreements. And if you were paying attention a few moments ago, you'll remember I said, well, if you have an agreement with a customer that you reach after they become obliged to pay you, that is a refinancing agreement and a borrower-lender agreement. So that would mean it potentially falls within this article. And this is an exemption for certain loans that aren't offered to the public at large, which presumably will be applicable, and where the interest rate you charge is a low rate, in essence no more than 1% above base rate. They all sound pretty well and good, and 10 years ago this exemption probably would have been very useful in the current situation. The problem is, since the implementation of the Consumer Credit Directive in 2011, this exemption now in fact in essence only applies to employee loans. So unless you're giving your employee time to pay, this is probably not going to be much use, even though on the face of it, at first glance, you might think that it might be. Okay, that is that. As I said at the outset, there is a time hopefully showing at the bottom of the screen along with my email address, which I will make myself available to answer any questions that you have, or at least try to. If you've got a question arising at any other time, by all means just fire an email to that email address and I do with what I can. It gives me an excuse not to homeschool my children, if nothing else. This is hopefully going to be one of a small number of talks covering sort of contractual issues that arise as a result of the coronavirus pandemic. The next one is going to be looking at force majeure clauses, what do they mean, how to use them, what can you do if you don't have one. Okay, thank you all for watching and I hope everybody stays safe.